Now let's discuss mootness, ripeness, and the political question doctrine. Mootness and ripeness are doctrines closely related to standing. A case is moot when a litigant who has standing at the start of litigation no longer has a concrete stake in the outcome due to changes in fact or law. For example, imagine that ABC Power Corp plans to build a hydroelectric dam across the Passaic River. The environmental group Friends of the Passaic files a lawsuit under the Endangered Species Act seeking an injunction to prevent ABC from building the dam because it allegedly will harm a rare kind of rat found only in the Passaic. Just after the lawsuit is filed, ABC abandons its plans for the dam. Friends of the Passaic's claim for injunctive relief would become moot. If Friends of the Passaic did not voluntarily dismiss the claim, it would be dismissed by the court. One thing to watch out for in cases like our hypothetical of voluntary cessation is whether any other potential claims remain that are not mooted by the cessation. For example, say ABC Corp files a trademark infringement claim against Pirate Co., and after the case is filed, Pirate Co. stops using the allegedly infringing mark. ABC Corp's claim for injunctive relief might become moot, but ABC might have an ongoing claim for monetary damages based on the period during which Pirate was using the mark. Another important exception to the mootness doctrine is the concept of a case that is capable of repetition but evading review. This means that the kind of harm at issue is likely to be repeated, but any specific interest of harm evades review because of mootness. As the casebook notes, a classic example of this kind of case was Roe v. Wade, the Supreme Court's first major abortion case. If a challenge to an abortion restriction is moot after the baby is born, then it would become virtually impossible for such a challenge ever to reach the Supreme Court. And yet the constitutional issue would repeat itself whenever a pregnant woman sought to challenge such a restriction. Ripeness is the flip side of mootness. A claim is not yet ripe if a party seeks only anticipatory relief. Courts generally will decline to hear such claims. For example, say that on July 1, XYZ Corp enters into a contract with Acme Corp that requires Acme to deliver a truckload of bananas to XYZ on November 1. XYZ hears through the grapevine that Acme is having financial difficulties and believes Acme will not deliver. So on August 1, XYZ files a claim for breach of contract. Because the contract has not yet been breached, XYZ's claim is not yet ripe. As an aside, in contracts you may have learned about the doctrine of anticipatory breach, which can overcome the ripeness problem in a case like this one. So, if on August 1 Acme delivered a notice to XYZ stating that Acme was repudiating the contract, there could be a ripe claim for anticipatory breach. There are other circumstances in which a claim might be justiciable even if it has not yet fully matured, such as declaratory judgment actions. For now, just know that ripeness is another doctrine tied to the Article 3 case or controversy requirement. This brings us to the last legal doctrine in this unit, the political question doctrine. Under this doctrine, the court may decline to hear a matter because it is within the discretion of the political branches, that is, the legislative or executive branches. Recall our discussion of Marbury v. Madison in Unit 1. Remember that, although Justice Marshall upheld the principle of judicial review, he also noted that the province of the court is solely to decide on the rights of individuals, not to inquire how the executive or executive officers perform duties in which they have a discretion. This limitation can be thought of as rooted in the text or structure of the Constitution itself, or as a prudential concern based on the limits of the judiciary's expertise. The principal case in our casebook on this topic is Baker v. Carr, a 1962 case. As you can see, this was an equal protection case in which a group of voters challenged the apportionment of legislative districts in Tennessee. These districts had not been reapportioned since 1901, even though the state had experienced major population shifts in the ensuing 60 years. In holding that this was not a non-justiciable political question, Justice Brennan summarized 6 factors that guided his determination. 1, whether there's a textually demonstrable constitutional commitment of the issue to a coordinate political department. 2, lack of judicially discoverable and manageable standards. 3, the impossibility of deciding without an initial policy determination of a kind clearly for non-judicial discretion. 4, the impossibility of a court's undertaking independent resolution without expressing lack of the respect due coordinate branches of government. 5, an unusual need for unquestioning adherence to a political decision already made. 6, the potentiality of embarrassment from multifarious pronouncements by various departments on one question. You may notice that factor 1 is a textual strand, while the other factors are prudential strands of the political question doctrine. The notes in our casebook after Baker v. Carr offer helpful examples of cases in which the court did or did not find an issue was non-justiciable political question. As you might gather from these summaries, the issue often arises in cases of significant political and constitutional moment, and there are no clear rules for applying the doctrine.